I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are doing our 11th compilation video. Today, we are going to be courtroom hopping into 3 different courtrooms for 3 classic proceedings that we've shared here on the channel. First, we are going to be in the courtroom of Judge Donna Milhouse, where she has a very aggressive sovereign citizen that I'm sure some of you may remember, and some of you, when you're introduced to him, may or may not like him, but we get a lot of comments on this particular individual. Second, we will be in the courtroom of Judge Brock Schwarzel, also out of the state of Michigan. And Judge Swartzle has a young man in front of him that thinks he is able to use a sovereign citizen argument to not pay his child support. And last but not least, for the third sovereign citizen, we're going to be in 2 separate courtrooms for 2 of his appearances. First, we're going to be in the courtroom of Judge Michael Cooper, and second, we will be in the courtroom of Judge Kevin Hesseling, both out of the state of Michigan. So we have 3 sovereign citizens, 4 judges on today. Know that there will be no commentary at the end, but there will be chapters in the video. So if you've seen one of these, you can just hop on to the next. With that being said, guys, don't forget to like, share, and subscribe. It is much appreciated. And with that being said, let's go ahead and jump into these proceedings.
People versus Albert Himmer Hicks. Names for the record, attorney first.
Okay, please court Harry Boffin on behalf of the defendant. Sir, would you state your name for the record?
Albert Heimer Hicks Jr.
Thank you. Good morning.
The defendant
Good morning, Your Honor.
that he does not wish to be represented by counsel this morning. I will remain in a potential advisory capacity just in case.
Okay, is that correct, Mr. Hicks?
Yes, that's correct.
Okay. You know that, so let me see what's happening here. I see an offer that ends up dismissing a lot of matters. I can't be your lawyer, so I'll just tell you what's here. And Corporal Spidell is here. See what I'm just trying to make sure I understand the offer. So you have 8 open matters, and there is a recommendation to dismiss 6 of those matters in return for a plea on 2 of the matters, and both matters are being reduced to driving with improper plates. I think, it was driving unregistered motor vehicle reduced to driving with improper plates. Oh, I'm sorry. And the other one is being reduced to, I don't get this other one, Mr. Jansen. Is it being reduced to failure to report accident under MCL 257.621?
Yes, that's correct. That's a 0-point offense that doesn't abstract, and
okay,
it's a maximum of $100 for a fine.
Oh, okay. So the false insurance information ticket would be reduced to failure to report accident, which has a $100 fine cap and is does not abstract for, according to the prosecutor, for insurance purposes. And then the other one would be to reduce the driving an unregistered motor vehicle to improper plates. And then the other 6 matters would be dismissed. Mr. Hicks, would you like to avail yourself of that offer? That takes something that was a $500 fine as the maximum to a $100 fine as a maximum with no points.
I never had a license. I never acquired a license. I have no contract with any company.
This has nothing to do with a license. So those license matters. The offer is to dismiss those.
You don't have to. I'll defend myself against them.
Okay. You want to go through all of these tickets then?
Let's run.
Okay, so let me just say, Mr. Hicks, if you're making a motion for, I'm not sure what you're doing. You
I'm
sure you
making
don't
a
want to have,
motion
let me
for
just
mistrial.
ask. mi-
I'm making a motion for a mistrial for the simple fact the officer did not have cause of action on private property. As far as the license is concerned, I'm going to rely on the decision from the Supreme Court and constitutional defenses.
Well, can you tell what those are so that the prosecutor can
Of course,
say what
I
she's saying?
travel with the common law. I have the right to travel. Shapiro versus Thompson states that. Murdoch versus Pennsylvania states no state shall convert a secured liberty into a privilege. Y'all are calling driving a privilege or traveling a privilege. It is not a privilege. It is a liberty. Shuttlesworth versus Birmingham says I can ignore the license and engage with the right with impunity. So you can't punish me for any of this.
Thank you.
I'm going total constitution on everything. This is a court of law and not equity. So all those civil infractions, y'all can wrap that up because nothing was injured. No one was injured and nothing was tore up.
Just so you know, Mr. Hicks, there are no civil infractions up today.
Those have to be civil infractions if you're trying to charge me money.
I'm just saying, you mentioned civil infractions, and I just want to make sure that you understand that these are all misdemeanor offenses against you. I'll go through them. Let me tell you what's up.
I already have them right here in front of me.
Well, I'm trying to do my due diligence, Mr. Hicks. Driving while license suspended, driving an unregistered motor vehicle, driving without insurance. Those are the 3 counts. Also pending is the driving while license expired. Count 1 is failure to display a valid operator's license, not on person. Count 2, driving unregistered or untitled motor vehicle. Count 3, driving with improper plates. And then the last one I have, the charge is providing false or fraudulent insurance information.
That will have to be proven.
Okay. Those are what they're scheduled for a bench trial before the court right now. And what I was trying to explain to you is that there's an offer that's been made by the prosecutor.
I understand.
Hold on 1 second. I'm already dismissing 4 of the matters because the officer has not appeared. Okay. So the prosecution couldn't go forward. So those are being dismissed without prejudice. And those would be counts 1, 2, and 3 of SP 1335615. I assume Officer Reed is not present. And that was scheduled for trial. I'm dismissing those, okay? The driver's license expired, case number SP 1218560. I'm dismissing that count 1 that's up as the officer Hernandez has not appeared, okay?
I wonder why.
Don't worry, a lot of people, that happens sometimes. Well, let me just say, let me just say, they may have been here before. I don't know, because some of these you haven't appeared for. So I don't know if the offer would change. So the only matters that are pending now, the other matters are gone, that were scheduled for today, would be the fraudulent false insurance information, SP 1055542, and SP 1055540, failure to display an operator's license, driving an unregistered motor vehicle, and driving with improper plates. Those 3. Right now, and I don't know if the offer would change because some of the matters are gone. But right now, with those matters here, the only plea offer that's being made would be to failure to report an accident, which has maximum sentence of a $100 fine.
What accident are they speaking of?
No. So just so that you know, Mr. Hicks, what the prosecutor does a lot of times is that in an attempt to resolve a matter, they'll have you plead, but they'll ask the court to accept the plea to a lesser offense that doesn't,
I
have
understand that doesn't
have-
hold as much weight as
yeah, that doesn't affect you as
I
bad.
understand it,
Okay.
but by the way that I live now as a researcher, I really don't need it. I do everything constitutionally. I
Okay.
don't follow laws or codes. I follow
Okay,
those.
well then that's what this is about. These are laws or codes.
Those are
Just
not
so
laws. Those are codes.
Okay,
Those
so if you,
They are not laws. The
well,
Constitution, there holds no weight with the Constitution nor the Supreme Court. And I'm
okay,
willing to take it all the way to
Your
the Supreme
Honor,
Mr. Hicks, just hold on, please. I'm just
No,
trying to get,
because it seems like you're trying to talk me into
I'm
something.
not trying to, absolutely not. That is not my role. Mr. Hicks?
From the
Mr.
Department of Transportation.
Mr.
I
Hicks,
have nothing to do with them. Never had a contract with them.
okay, Mr. Hicks. I'm not trying to talk you into anything. I just want you not to come back and say that I didn't explain something to you. And I am not your lawyer. I'm the
I
judge.
understand.
So I just want to make sure though, that you don't come back with something else. And I just wanted to let you know, because you didn't talk to the attorney, what was being offered. That's all. And you made your argument. I'm going to have the prosecutor make an argument, but I've already gotten rid of some of these, okay, for other reasons. And so I just want you to know that at least with respect to the offer that was made before, and it may have changed, these other three matters would be dismissed, I think. You know, yeah, yes, these other three matters would be dismissed. The failure to display, the driving unregistered, and driving with improper plate. But that's only if you plead.
I will not plea. I refuse.
Okay, all right.
to plea.
No problem then, Mr. Hicks. I'm just telling you what that offer is from the prosecutor.
I
It has
understand.
nothing.
I
So,
understand. I'm 57 years old. I speak English well, and I translate it real well.
okay,
I even
I'm not
have you on
saying-
caption. I'm reading
Pardon?
everything that you're saying.
okay, all right. That's good. I just want to make sure there's no issue. Attorney Jansen, what about so we have 4 matters that are pending. Office Corporal Spidell is here and he's here on those 4 matters.
yes.
Okay,
Your Honor, go ahead.
go ahead. So Mr. Hicks has made a motion before we move forward with the trial.
Your Honor, I guess I would like to speak with Corporal Spidell about these cases. But prior to that, I just wanted to clarify that the defendant has submitted to jurisdiction.
Thank you.
Thank you. I have had the
Yes.
chance to speak with Corporal Spidell, who was the ticketing officer on this case.
Okay.
We are requesting an in-person trial date.
Beautiful.
So just for the record, all we have left are the 4 misdemeanors that I indicated.
Yes, Your Honor.
Okay, all right. But I need you to be ready to respond to Mr. Hicks's motion. He just made an oral motion. I don't know if you want to do that now or do that at the time.
I can do that at the time. If he could actually reiterate his motion in writing, that would be
Can you
helpful.
put that motion in writing, Mr. Hicks? And you would have to give it to the prosecutor, Attorney Jansen.
Well, the thing is, when I was reciting it, no one was taking record of it.
We
So
have
that-
record. We have a record of it, Mr. Hicks.
So
I mean, we have a record of everything. No. Let me tell you, Mr. Hicks, a lot of times written motions are required. And usually, and if that happens, then written responses are required.
Okay, beautiful.
I'm just trying to,
Where would I bring or send these motions?
you can file it with the court and with a copy to Attorney Jansen.
You will have to send me that information because I have nothing to jot with at this moment.
She'll chat it to you. But the filing with the court is different. You should already know how to, there's nothing special about that. Okay,
I can't-
and give me 1 second. I'm gonna try to get a date. So that means you would come down to court.
I wanted to do it in the first
Yeah.
place.
Okay,
For,
all right. It is still scheduled for a bench trial.
Beautiful. For a bench trial.
So I can schedule this for the, adjourn this bench trial until March 27
Hold on.
in person,
Mm.
9 a.m. It's right now it's scheduled for a bench trial. And so that's what we would have been going forward, but we'll move it then in person. So make sure that you come in. If you have any witnesses or other evidence, make sure they're present. And if there's any motion to be heard prior to the bench trial, we'll do that.
I said everything I had to.
Do you have that, Ms. Jansen?
I asked for a mistrial.
Yes, I've
Yes.
emailed Corporal Spidell with that date,
Call for action.
March 27
Okay.
at 9 a.m. Thank you so much.
Our schedule.
Uh,
Hopefully we can get started
Judge
close to that
Milhouse.
time. Yes,
Judge,
Mr. Hicks.
are they gonna have me just sitting around like I'm doing today? Because I do have a business that I run and I will be asking for costs and fees.
Well, you wouldn't be able to get costs and fees
Why
for
not?
sitting around because that's not anything that's allowable.
Oh, it's not?
No, it's not.
Law.
It's not allowable. It's not allowable because the court has to do its business for everybody. Okay?
Even when I win this, I'm not allowed my costs and fees?
We're not going to talk about that. You were talking about sitting around and waiting. So you're not.
I mean,
You're not.
like a game to try to pressure me out. But
Oh, Mr. Hicks. So Mr. Hicks, just like I'm not imposing any costs and fees on you when you missed your court dates. You missed court dates earlier. And you've been doing that. I see it.
I walked in the same day down at 36th District and
So
rescheduled.
Mr. Hicks, I already made my decision now. Come on. I made my decision. You asked me and I said I wouldn't be able
Please
to
don't
do.
try the intimidation thing.
I don't ever intimidate. You know what? You can only let me just, Mr. Hicks. I'm gonna talk to you, Mr. Hicks. Can you listen to me for a second? You can only be intimidated. No, yeah, you can only be intimidated if you feel insecure. So if you feel insecure, that's where that comes from.
Not feeling
So
insecure.
nobody's trying to do that, Mr. Hicks. I just say?
We'll see.
But Mr. Hicks, can I just say that you've been given I don't even want to say, because we've been following the law, you've had cases dismissed because that's what we're doing. Because of it. Not in spite of it. Okay. So I hope it's fine that that's happened. So we're down to 4 matters and it sounds like you have no problem with coming in. Correct?
I still would like a jury trial. I would love a jury trial.
You're wanting a jury trial?
Yes, that's what I asked for in the first place.
You asked for a jury trial at some point and didn't appear. And so it went into show cause status.
That was done on purpose. That was done by design.
You did?
Thing inside of what's that little township? Every time I ask for a jury trial, no one wants me to come in and speak my law, speak the Constitution in front of people.
Wait a minute. So you didn't, I'm just saying, you didn't appear several times. I'm looking here. So let me just say, if you want a jury trial, I have to give you another date. I didn't know that. So because the last time you were
filed, I have a paper here that says I would like a jury trial.
Okay, Mr. Hicks, I scheduled a jury trial for you. It looks like a couple of times, and you did not appear. So
yes, I did.
Okay, but let me just say, we were ready. Okay, Mr. Hicks, you want to get some counsel for that? Because it really takes a lot. I can't be your lawyer. we have to choose a jury. There's a lot of things that happen. And if you don't believe in the law to begin with, let me do this. Let me
I
do
don't
this.
color law. I believe in the Constitution, the supreme law.
Mr. Hicks, you can put your motion in writing. Ms. Jansen, you respond to it. And we'll schedule that for a hearing date. Then you don't have to come in. And then we'll see if this moves forward. If this is moving forward for a jury trial, I have to give you a jury trial date. That's completely different from a bench trial date. Okay? Like our scheduling is different.
I'm getting the fees out of this.
Well, I'm just saying. I don't know who can award them to you.
The court can. That's totally
Miss, hold on. Well, why don't we do that? We'll use the March 27th date as the hearing date on Mr. Hicks's motion. That I think your motion is, so you were saying something about not being subject to
no cause of action on private property.
Okay, so why don't you put that in writing?
And I will.
Put that in writing, and Ms. Jansen will, so that needs to be filed by, I'll just indicate.
And just for the record, is suspicion a misdemeanor or a felony?
Oh, you don't have any felonies.
No, I said is suspicion a misdemeanor or a felony?
These are, you don't have any, these are not felony cases. These are all misdemeanor cases.
Beautiful. So he had no cause of action on private property.
Well, I don't see that as, if you want to just do an oral motion right now, Ms. Jansen, you can. I don't know if you're prepared for it because he's saying that now.
I said it at the beginning.
Okay. No, I mean, at the beginning of today.
I'm so sorry, Your Honor. I don't know what he means by what he's describing. This is a ticket that if we want to go into the facts, then
No, you don't have to.
Yeah, go into the facts. Come
No,
on.
no, because I might have to hear. No, we can't do that.
With the Constitution.
Not
I'm
with
waiting
me.
on him. Make sure he's there.
Mr. Hicks.
I see him in the neighborhood anyway.
Your Honor,
Mr. Hicks. Mr.
Okay.
Hicks. Mr. Hicks.
I have nothing else to say. Y'all
Mr.
using color
I'm going to
law.
request a bailiff. Your
Yeah,
Honor.
request one, please.
Mr. Hicks.
Is she scared? Tell her to call the police.
You don't need one now. He's at home.
They do not want to go by the Constitution.
Mr.
It's a good
Hicks.
thing I'm filming this too.
Mr. Hicks. You're not supposed to film it.
Oh, yes, I can.
No.
I can do anything I want to in my house. You have no thing underneath my private property. You have no
Okay.
control.
All right. We'll see you. All right. I don't know what to tell you. We'll see you on March 27th. You can file the motion.
I will.
Make sure the motion is filed by,
I got 14 days or so.
I'm just gonna give you a little bit more.
Judge Milhouse, I have no problem with you.
I mean, but Mr. Hicks, I don't need you to become angry.
But
That's the thing. That's the thing.
No, that nobody wants to follow the law.
But Mr. Hicks, people can disagree about what the law
No,
is.
it's not about disagreement. It's right or wrong.
Well,
It's
Mr.
right
Hicks,
and then there's wrong.
Mr. Hicks,
It's not about disagreement.
Mr. Hicks,
The Constitution was written so it wouldn't be no disagreements.
Mr. Hicks. Oh, there's always argument about the Constitution, always. Just so that you know, just so that you know, yeah, you wouldn't need me if there wasn't. So, I just want you to understand that, and what we have to be here is civil, okay? We really have to be civil with this. We really need to be civil with each other, and I appreciate
not using the same tactic.
Yeah, but there's no tactics here.
Yeah, it is.
Well, I'm not trying to do a tactic. So let me just give you a date, and you can send it, and be careful.
I'll bring it personally.
I just so for the record, because I have to say it for the record, I have scheduled some jury trial dates for you in the past, and maybe, I don't know if it's on any of the matters, probably on some of the matters that I'm
It's
just.
not in my paperwork,
Just today, just for today, I'm saying.
but it's not inside of none of my paperwork.
Okay,
And I'm
well, I've
frequent.
said it on the record, so
Okay.
those count. And I listened very carefully. And the last time I scheduled these matters for bench trial, it helped you because there's some officers that did not appear today, and so those matters are dismissed.
Matter of fact, do me a favor.
I can't do you a favor.
Please call the other cops in.
No,
Bring
I'm
them
not.
I'll take on all of them.
No.
Sworn
No.
on the Constitution and don't know it. I'll take them all on. Let's get it.
Okay,
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter. And then at some point in the future, we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court, on this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322-BR-719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for it incentivizes them to collect more child support. The main argument I have here, and for you guys, is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically it's evidence is they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case, and then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
Turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay.
George.
I think I just heard him. He's coming on. All right. Okay,
Thank you, Your
Mr.
Honor.
Hargrove. Go ahead, Mr. Baber.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I am.
I do see that in your motion. Okay, give me just a second to.
And I want to stress to the court too that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, you know, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes, I mean, that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it, I'll answer it if I can.
Are you the trustee for the Sesta KV account, Ronald Gene Hargrove II, or
any account thereof?
Are you asking me that question? I have no idea what you're talking about.
You don't know
I
what I'm talking?
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw saying that he can't, basically you have a disagreement on how to proceed. That's too significant for him to proceed.
Oh, okay.
All right, so I'm going to allow him, Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one. What do you want to do?
Well, I guess I'll go forward with an attorney and
Okay, so here's
I have a witness and some other things.
Okay.
I guess I need an attorney.
Well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you call, or that attorney, would you also let them know they may want to call Mr. Baker?
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
So you don't have to answer my question?
All right, Ronald Hargrove, file 24-43189 ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement? I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then, yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there is an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go. Is that what you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right. Well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my Cesta KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry, what? I don't understand what your question is.
How can you be the trustee of the Cesta KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The Cesta KV
Yes, it
account
is, but
that everybody, most people have, and you're the trustee. Just like the Secretary of State is trustee of it. You are my trustee, aren't you?
Not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
what leads you, Mr. Hargrove? What leads you to believe that I'm your trustee?
Because of a former case I've seen.
A former case? What former case are you referring to?
In Roscom, and a friend of mine asked the judge that, and he couldn't answer him. So
that's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff. So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
So you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
what information do you have?
If it was a misdemeanor,
go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay, well,
there has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
No. I just believe that you are my trustee of the Cesta KB account, Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess, and another thing is I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the state.
Then you need to ask the Secretary of State.
Well, I believe I have my license, and they just there's a screw up somewhere.
Then you need to contact the Secretary of State, but I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Okay. Well, knowing that I think I had a license at the time. Doesn't that change things?
It would change things only if it were true, and I don't know that it's true.
I don't
Just
either.
because you believe it doesn't make it true.
Yeah.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interests is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
I'm not threatening you. Say one more word and that's 30 days. 30 days.